Hello, uh, dear all. My name is Anikó Keller. I am partner with Szecskay Attorneys at Law, leading independent law firm here in Hungary. I am really very happy to have the opportunity to welcome you on one of Gala's traditional events, the EMEA Year in Review. This year, a panel of advertising law experts will again cover the most relevant developments in the field of advertising law in 6 countries of the EMEA region, namely the United Kingdom, Switzerland, Slovakia, Hungary, the United Arab Emirates, and Ghana. Please let me introduce our panelists in the order of appearance. Brinsley Dresden of Silkin from the United Kingdom, Delia Fehr Bosshard of VISCHER from Switzerland, Dusan Nitschneider of Nitschneider and Partners from Slovakia, Mariam Sabet of Tamimi from the United Arab Emirates, and last but not least, Esohe Olajide of the Integrated Legal Consultants from Ghana. As you will hear, hot topics include sweepstakes and contests, influencer marketing, green marketing, gender-related issues, and many more. Please know that we have a chat box and a Q&A panel, so I do encourage you to ask questions, make comments, and share your opinion with us. I will now turn it over to Brinsley Dresden, our first speaker from Silkin, who will be sharing with you the most interesting developments from the United Kingdom. Brinsley, the floor is yours.
So in the Fines traditions, you will have noticed that my microphone was muted when I started speaking. And that was, you might think that was an accident, but in fact that was deliberate because I wanted to kind of, get off to a traditional start for a webinar where the speaker starts speaking. But I was wanting to see, as Captain Mannering from Dad's Army used to say, who is going to spot my deliberate mistake. So, hello again. And as Anikó has said, these are the matters on which I'm going to cover, so I shall just get straight into it. The first of which is concerning influencers, and I wanted to look at the ISBA Code of Conduct and a couple of recent ASA decisions. For those of you who don't know, ISBA is the Incorporated Society of British Advertisers and is the UK's leading trade association, equivalent, if you like, to the Association of National Advertisers in the United States, representing, I think, around 300 of the UK's largest advertisers. And the ASA is our regulator, the Advertising Standards Authority, which is a self-regulatory organisation. And they are the people who 99 times out of 100 are dealing with regulatory issues in relation to advertising and marketing in the UK. So the ISBA, in the autumn, they've released a code of conduct for influencer marketing. As you can see, it's got 3 aims. The first and perhaps most important is to deliver transparency about disclosure of when an influencer's post is an advertisement, so when there's been payment and when there's been any degree of editorial control by the advertiser. And one of the slightly controversial things about the code is that ISBA has very much defaulted to saying that the disclosure should be by using the hashtag ad. And as we'll see, not all advertisers want to use that. So there was some controversy about that, but nevertheless, that's what ISBA has committed to. The second aim was to enable authentic and effective influencer marketing. So I think, in other words, allowing influencers to give their own genuine opinions and not being too dictatorial when working with influencers and requiring them to give opinions that they don't necessarily subscribe to. And also about promoting diversity and inclusion and making sure that there is better representation of all groups amongst influencers that companies use. And finally, about improving brand, agency and talent relationships, aligning the talent and the brand and promoting collaborative working. There has been a investigation through one of the parliamentary select committees about influencer marketing this year. One of the things that came across was that a lot of influencers were suffering bullying online. And so there's been some concern about how to perhaps protect them from that. So against that background, we've had a couple of quite interesting ASA decisions. there have been lots of decisions which have just been the standard kind of, oh, this influencer hasn't given any disclosure. So because they're so much the same, I haven't really bothered to talk about those, but there's two which I thought were interesting. The first was this one by an influencer called Emma Louise Connolly for Bowl Foods, and you can see there, which is Bowl Foods is a vegetarian, vegan kind of food product. In this case, she was promoting a noodles product, and you can see here, there's no ad, hashtag ad, or any kind of disclosure of this as an advertisement, which was deliberate because the influencer didn't think that this was an advert. So two people complained about her Instagram post and said, well, it's marketing, but it's not disclosed. She said, well, I'm an investor in Bowl Foods, so it's not an ad. But going forward, I'm prepared to, when I make influencer posts about this product, I'll use the hashtag Team Bowl. But the essay said, no, that's not sufficient. And even though you might have put on your profile page that you are an investor in Bowl Foods, that also is not sufficient. You need to disclose these posts as ads on each occasion where you post for them. So this idea that an influencer who has some kind of equity stake in a product or service which they're promoting or posting about, and that somehow that makes it not an advertisement, any such argument I think now has been disposed of. Another interesting one was this one for Primark stores, and Gabby Dawn Allen, who is from the TV show, which is certainly very popular in the UK, called Love Island. Now here you can see she's put at Primark and then hashtag I work with Primark. And again, only the one complaint in this case, and people saying, well, it's not clear that I work with Primark is actually indicating that this is an advertisement. The Primark and Miss Allen said, well, it was part of the contractual relationship that I would use it. And, you know, surely I work with Primark makes it abundantly clear that I'm being paid to do this post. But the ASA didn't agree with that. And they said, no, it's ambiguous, it's too long. And the meaning wouldn't be immediately obvious to consumers. Also, there was a problem that it was positioned wrongly at the bottom of the post when it should have been at the top. So that complaint was also upheld. So what we're seeing now is that, you know, the ASA continuing to basically uphold complaints when anybody tries to use anything other than hashtag ad, and this kind of very strict interpretation of the rules has been endorsed effectively by ISBA, who've written this into their code. So for any advertiser that would like to use a disclosure other than hashtag ad, it is proving increasingly difficult. Now, the next one I'm going to talk about is the portrayal of LGBTQ plus community in advertising. And actually, I'm really doing this knowing that colleagues, other speakers on this event are going to be talking about this issue. So this is a bit of a sort of compare and contrast between the UK and some of the other countries represented on this webinar today. And I've picked out this one, an ad for Cadbury's Cream Egg. You can see two chaps having a kiss with a Cadbury's Cream Egg, but passing between their mouths. It's quite a suggestive image. There were no regulatory issues in this ad. If there were any complaints made to the Advertising Standards Authority, they didn't uphold them. I don't think they made an announcement about them. And so I think this illustrates really quite how liberal UK media has become and quite how liberal our regulators are. So it'll be interesting to see perhaps when, I know Anikó is touching on this issue, maybe there'll be an opportunity for her to speculate as to how this would be received in Hungary. Next, green and environmental claims. So I'm just checking my time here. My stopwatch has helpfully gone off, okay. Green and environmental claims. So this one, we've had major developments in this area this year. In particular, the Competition and Markets Authority, which is our statutory regulator, so this is effectively the government regulator, issued what they called a Green Claims Code to provide guidance about compliance with the CPRs, which is the Consumer Protection Regulations, which is the UK version of the Unfair Commercial Practices Directive. And although obviously that's a piece of EU legislation, it's continuing in force despite Brexit. And the CMA have said they're going to do a full review of green claims in early 2022, which follows concern about the fact that there's a lot of, they think that consumers are being misled on quite a large scale by misleading green claims. And certain sectors, in particular fashion, are going to be prioritised in that review. The Advertising Standards Authority also made a statement soon afterwards, and they're going to be issuing further guidance and doing their own inquiries and looking into what consumers understand by claims such as carbon neutral and net zero. The Green Claims Code, these were the key provisions of the Green Claims Code. These are all exactly the same principles which have been long established by the Advertising Standards Authority, and so no real change there. They speak for themselves, very consistent with the ASA rules, which is helpful. It would have been very unfortunate if they contradicted the ASA rules. And a couple of interesting ASA decisions. This is an advert for a hydrogen fuel cell powered car. And you can see there's a woman on a treadmill in a bubble, which is hooked up to the tailpipe of the car. And the headline was, "A car so beautifully clean it purifies the air as it goes." And the ASA upheld a complaint from one person, presumably some kind of environmental activist, who said, well, there's still dust is released from the brake pads of a car and from the tyres as they wear on the road. And therefore, it's misleading to say that a car, even a hydrogen fuel cell powered car, purifies the air as it goes. Personally, I think that was an overly restrictive interpretation of the rules, but who am I to say? It was the ASA that made the decision, and they upheld the complaint. And the ASA also upheld the complaint about this ad for a almond drink and also an oat-based milk drink and a plant-based yogurt. Very unhappy with this very general claim, good for the planet. Again, only the one complaint. It was, although they had, Alpro had good substantiation for a cradle-to-grave analysis of the environmental impact of 2 of the 3 products shown, they didn't have any substantiation for one of them, which was a problem. And the other problem was, what does good for the planet mean? In what way are these products good for the planet? And the burden of proof is on the advertiser, so that was upheld as well. Then finally, from me, the HFSS restrictions. These are very significant as well. And finally, after a long consultation, the government announced that we're going to have a complete 9 p.m. watershed for TV ads for HFSS products. In other words, they can't be shown before 9 p.m. You can only show them after 9 p.m. because we're trying to stop children from seeing them. And also a ban on paid for ads online. At one point, they were talking about even banning claims on companies' own websites for their products, but they backed away from that very draconian idea. And then the other developments, which was in parallel, was this ban on for certain types of sales promotion for HFSS products. So volume-based restrictions. You're not going to be able to make buy one, get one free type offers that we call bog-offs, or 3 for 2s. And there's also going to be location restrictions about where you can promote HFSS products. For example, at the end of an aisle in the supermarket is going to be banned, and also on certain places on online websites. And then just a quick word just to mention my own resources and sources. If you'd like more information, we have our Ads and Brands Law Digest, which is particularly aimed at in-house legal counsel and goes into quite a lot of detail about different developments in advertising law and regulation, and our blog, adlaw.lewissilkin.com, with lots of ad law insights. That's me done. Over to the next speaker.
Thank you so much, Brinsley. This was really interesting, and I'm coming back to your example with Cadbury's once if it's my turn. But now I'm giving the floor to Delia from Switzerland.
Thank you, Brinsley, and thank you, Anikó. So hello from Zurich, actually today. I wanted to highlight a few recent developments in Swiss advertising law and practice. I won't cover all the details on the slides, of course, just to give you a little background on some most recent developments. I think something that will be of interest for advertisers in Switzerland is the upcoming revision of the Data Protection Act. As you know, Switzerland is not part of the EU, so we do not have the GDPR directly applicable. Of course, it was a model when the revision was ongoing. We now have a final draft act. The authorities are still working on the ordinances with a lot of details relevant for advertisers as well. We will include and follow some of the concepts of the GDPR. We'll have higher sanctions than we had before, more compliance burdens, etc. But it's important to note that this won't be a copy of the GDPR. We are actually now thinking that the entire package will come into force in 1 or 2 years. We will see about that. So that's something to follow, maybe. So then another important topic recently in Swiss law and practice is the regulation on sweepstakes and contests. We have a recent new federal law on money games, which is triggered basically whenever a game is offered against the monetary stake. So that could be a purchase of a ticket, an entry fee, a purchase of goods and services, or participation via a value-added phone number. So these are classic examples. And whenever such game is involved, you technically have a prohibition. So money games are generally prohibited. There is an important exception for promotional games offered on the Swiss market. If you offer a lottery or game of skill for a short period of time for the purpose of sales promotion, not posing a risk of excessive gambling with a participation through the purchase of goods or services offered at regular market prices or lower, and if you offer a free participation route, this will be an allowed promotional game. The free participation route, and that's new in Swiss law, is not required generally for promotional games, but only if a media company is organizing such games. So this is something that's actually becoming more complicated for media companies than before, whereas other advertisers can use those promotional games without offering a free participation route. So for the details, for the criteria, the short period of time is more or less defined as 1 to 3 months. We deem less than 6 months to be okay, depending on the circumstances. You have to link that promotion to the purchase of a product or as part of a customer loyalty measure. And that sounds easy, but we have seen in recent cases that it's actually quite difficult to, especially media companies, broadcasting companies, to make that link and to show that link close enough. The requirement that your game does not pose a risk of excessive gambling is not new in Swiss law and basically applies to most of those games under the Money Games Act. We usually argue that if there is a free participation route, there is no risk of excessive gambling. I'll come to that right now. So the participation through purchase of goods or services is now a valid criteria, a valid condition to participate. As I said before, for the media companies, you have still this requirement for free participation route. And that way of participation requires equivalent access and participation conditions. That's not new under Swiss law, but it only applies nowadays to media companies. So you have objective criteria to follow. You cannot have a disadvantage compared to paid participation, but you also have to kind of make sure that your audience does not deem this such disadvantages compared to the paid participation. So that, of course, depends on details in off text, in the way you present your game, and has proven to be quite a difficult criteria, especially for media companies. The reason why I'm focusing on this part especially is that we've seen a lot more cases this year, a lot more enforcement actions from federal and cantonal authorities, and especially criminal proceedings actually against the individuals responsible. And there are fines involved and possible monetary penalties. But besides those criminal complaints, there is also just the possibility that the ad itself will be subject to civil actions or complaints with self-regulatory body. And we have seen an increased awareness and for those type of games with the authorities in question. So really just a quick note on recent product regulation. We will have a new federal act on tobacco products, sorry. There is a ban of advertising if it's targeted at minors, so below the age of 18, but there's no general ban of advertising for those products. The law is still subject to a potential referendum. There will be fines, but to sum up, it will not be as strict as the WHO Framework Convention would foresee for those type of products. So Swiss law is still less restrictive in this regard. Also, just a quick note on changes regarding like more formal criteria on how to present your pricing information and discounts. There are some things facilitating advertising, so you can make use of online links instead of including all the necessary information in your actual marketing materials. That's something that's really just following the actual use of online sources already in the market. We have seen more enforcement activities also from the federal authorities, but also the cantonal authorities with regard to the very detailed criteria we have for price comparisons. So if you're advertising a discount, if you're comparing yourself with a competitor with regards to pricing conditions, that's something that's rather strictly regulated in Swiss law, and we have seen a lot of cases on that as well. As Brinsley did, I want to show you some recent developments in the field of influencer marketing. So far, we only have recommendations from the regulatory body. The cases were mainly focusing on the separation requirement. We do not necessarily require hashtag ad or the like. And it was the question whether or not it was required for a particular post. Maybe it's important and interesting to know that if you need some sort of hashtag, it doesn't necessarily have to be hashtag ad. So there is no decision so far and no rules in the law saying what actual hashtags, disclaimers you have to use. We have decisions on individual hashtags saying that this or that was not sufficient. We do not have any wording requirements, any language requirements for precision. I quickly show you some of the recent cases that were decided from the self-regulatory body. So it was okay to have a post by Roger Federer featuring the logo of his current sponsoring partner without hashtag ad. It was deemed clear that this was advertising for his actual sponsor. It was not okay by a professional snowboarder to post that picture of him entering a store of his sponsoring partner without a hashtag ad. So here, apparently, it was within that existing sponsoring relationship not okay to not label that as an ad. And then we had another case, amongst others, from an influencer. She did not actually have a contract or a sponsoring relationship with that jewelry brand, but this really wasn't of importance for the self-regulatory body. It was still okay without ads, as it was clearly, in their view, clearly commercial communication. We kind of surprisingly, to be honest, have a constant caseload on gender discrimination and sexism issues, mostly focusing on the depiction of bodies, mostly female bodies, but not only. And there the question to answer is always, is there a natural connection between the portrayal and the product or not? Is the body really depicted purely as a decorative function? I really just included some of the many cases we had in front of the self-regulatory body. As you can see, none of those bodies depicted really has a direct connection to the either tires, products of a sawmill, or the services of a plumbing company. So these are the rather clear-cut cases there were. Another quick note on consumer credit. We have there a co-regulation of the statutory provision in federal law against aggressive advertising for consumer loans, and the self-regulation of the Swiss consumer finance industry. And it's interesting. I think that this regulation, which is not new, really leads to cases on a regular basis, which aren't in itself very heavy cases or very heavy violations, but they still raise a lot of awareness and still raise a lot of media attention. And so I think that's noteworthy. Also, this regulation is specifically targeting the protection of young adults, so not minors below the age of 18, but young adults below the age of 25, and that's something particular for Swiss law. With the field of country of origin claims, we have new laws since 2017, but also in this field, a lot of enforcement action this year. It is important to know that federal law governs use of all designations of geographic origin, so not only Swiss origin, but all such claims used on the Swiss market, whether it's made in the UK or any other claim. And it, of course, governs the voluntary use, so within marketing or as a trademark, not the mandatory disclosure requirements. You may use the Swiss cross in Swiss advertising or as part of your trademark, but you may not use the Swiss coat of arms, which you see below for any of the products if you are a private supplier. We have precise definition of origin for all types of products and services in the law. If you use a Swiss-made claim or any such thing in advertising, it will be considered to cover all promoted products. So that's something that sometimes proves tricky for marketing materials. You can, if your product does not fulfill the criteria, just highlight a particular origin of a particular activity. So for instance, Swiss research, Swiss design, that's allowed. We do, again, have criminal sanctions possible as legal risks. We see, for instance, competitor claims raised, but you also have reputational risks because we see quite a lot of cases in front of the self-regulatory body and they publish their recommendation. It's usually quite easy to see who has been a subject of such complaint. So one interesting point here, it is a national Swiss law that regulates the country of origin claims, but we see, or we have seen for years, enforcement actions abroad. That's really special. The so-called Swissness regulation foresees that our trademark office is actually becoming active abroad by monitoring trademark applications, sending notices via local embassies. They are even involved when foreign trademark offices receive trademark applications bearing, for instance, a Swiss cross. And so that's something I think that's really noteworthy and special and out of the ordinary in this regard. So to sum up, just a quick outlook, some topics that will become relevant. We have an early draft of a federal law on the protection of minors in the area of film and video games. It's really too early to tell, but I foresee some impact on advertising, and it will be rather a broad field of application. Also, providers of streaming services, for instance, will be subject to that regulation. And there is a new target in federal law, the communication platforms, and Switzerland is not the only jurisdiction addressing those platforms, I know, but we are currently seeing a mandate for a report and potential legislative drafting for a federal act in this regard, targeting, of course, hate hate speech, fake news, etc. But I would also expect some impact on advertising in this regard. So that's it for me from Switzerland.
Thank you so much. Thank you so much, Delia. This was really, really informative. A lot of things happen in Switzerland, obviously. So now I'm giving the floor to Dusan. Please, Dusan, the floor is yours.
Hello, Anikó, and hello, everybody. I'm Dusan Nitschneider. I come from Slovakia, and I will try to describe these 5 topics to you, as I consider those 5 as the most important things that has happened or are already happening or are still happening in our country in the field of advertising. So, green marketing or greenwashing, we as the country are, let's say, moving from, let's say, coal energy or coal electric energy to a sustainable or more sustainable energy of solar or wind. And one of our biggest, or technically it's the biggest Slovak electricity seller, introduced its new product, which he named Clean Electricity. And he introduced it with the campaign which tried to attract the attention of people. And let's state it that clean electricity product, your household can have electricity exclusively from renewable sources for only €2 a month. But this quite an honest advertisement was claimed at the Advertising Standards Bureau, and it was claimed that technically it is not possible to distinguish between the energy which is produced from the current, mostly coal sources, and the renewable energy, because it's just the wire. It cannot distinguish that this part of electricity was done or was produced in a normal way, and this was produced by a sustainable way. And unfortunately, the self-regulatory body, which is the Slovak Advertising Standards Bureau, they claimed, or they found out, that this claim or this campaign was misleading just because of the technical factor, because normal people cannot understand the technical way, and that they will probably were misled that if they pay €2 more per month, that they will just completely use the green energy, which of course was not possible. So we will see. This was quite recent one. This was from September. We will just see the campaign was withdrawn and the advertisements were pulled off. We will just expect how the reaction of that electricity seller will be probably in the beginning of the new year. So, second thing, I'm pretty happy for that, because we are moving from being too conservative country or too conservative advertising sector to, let's say, being more liberal. Just one remark at the beginning to Brinsley's example of Cadbury cream egg advertising. Unfortunately, I think it will be forbidden here because we are still too conservative. I remember an ad, a TV ad made by Durex, which is the company producing condoms. It was like 30-second spot where, let's say, lots of couples were kissing, and of course it was just bringing the atmosphere that the sex is going to happen in near future in that TV spot. And one of the couples was gay couple, and it was very criticized ad, even if the ad was running on TVs after 10 p.m. and it was, let's say, it was ruled by the ASA to be withdrawn. So coming back to CBD, CBD products finally have been legalized in a way that CBD was removed from the list of prohibited things or prohibited narcotic drugs list, which means it was not completely legalized. They're saying, or nobody was encouraged to, let's say, to use it by the law, but it was just removed from the forbidden list. And now all the companies can sell and can promote the products which contain the CBD. Despite of that, marijuana, as the plant which contains CBD, is still on the list as illegal substance. and let's say using and let's say holding marijuana even for self-purpose is still a criminal act. So we are moving slowly but surely. Another thing, influencers. At this moment, the influencers or the influencer advertising was governed only by the general principles of advertising itself, but the Advertising Act, it's quite, let's say, an old one. It comes from 1990s, and it covers, of course, all forms and all types of advertising. It doesn't specifically says anything special about, or it just covers the most typical forms of advertising like alcohol or tobacco, but doesn't go too much into detail about influencers. Of course, influencer marketing is running quite a lot in Slovakia, but has no regulation, not even a guideline. Now let's say it's called Interactive Advertising Bureau, which is a self-regulatory body that, let's say, covers the online or social media advertising, decided that they will prepare a guideline, or it's like code of ethics, especially for influencers. We were chosen, luckily, to help them with drafting of that code. It's still not yet approved, but we expect it's going to be approved and introduced into the live, let's say, first quarter next year. The most important thing is that in order to, let's say, achieve the transparency and disclosure, we will, or the code will introduce the hashtag something. There are still discussions that if there will be allowed hashtag and English pronunciations or English or international words like ad or sponsored content or paid partnership. And along with those, of course, the Slovak versions or Slovak translations of these will be introduced too. So there will be a variety of hashtags that could be used to distinguish between my private content or influencers' private content and influencers' paid content. The code will also include some other, let's say milestones. It will contain some provisions about protection of minors, of course, where influencers having certain threshold, which was not decided yet, of minor followers, will not be allowed to advertise certain type of products. There are going to be some restrictions about health claims and, of course, violent and hateful content. So we are pretty happy that this is happening in the country. So we might, let's say, say that we are moving, or our environment is moving westwards, I suppose. Then one thing quickly to mention is that we are going to have a new act on audiovisual media service that is going to replace our current act on TV and radio broadcasting. The reason is that we want to implement the European legislation, and let's say the reason behind is that the new Audiovisual Media Act would like to cover not only the TV and radio as it was or as it is right now, but will also include on-demand TVs or internet TVs and the, let's say, video media channels under its regulation. So things like Netflix or Vimeo or YouTube will be regulated, and they will fall within the scope of this act. Another important thing about this act is worth mentioning, which is that first time ever in the history of Slovak Republic advertising, there is going to be implemented some new structure of regulation. We call it like co-regulation, because in general, advertising in Slovakia is purely self-regulated. There is going to be established a state-organized bureau, which will, let's say, act as the head of the regulation, but also a list of self-regulatory authorities will be appointed, and the scheme will go the way that if there is a claim or someone, let's say, questions some claim, First, it will go to self-regulation or self-regulation body, which will be chosen from the list. If this self-regulation body will not act or will not decide on it within 90 days, it will go up in the structure to that state-appointed body. So we will see how it's going to work, but new things are happening. We will see. And last, and probably the funniest thing to mention is that what's happening right now in Slovak Republic, what's happening is creativity, and quite funny example of that is that old meme or old picture of Bad Luck Brian was used for an advertising of a very small, probably the let's say family dental dental clinic. They just prepared the campaign the way that it hit the national TV and national papers in a way that they just ordered a couple of these big boards, well, 2 or 3 big boards to be totally precise, three big boards in Bratislava, which is very few, and it was very cheap, with a picture of Bad Luck Brian, stating with the claim stating, with invisible braces there are no such memories. And they have pre-arranged the consent of Mr. Kyle Craven, who is Bad Luck Brian himself. And after posting it on the big boards, they just posted a picture of that on the social media among or into the Facebook and Instagram groups of advertisers with just the question like, do you think they have permission to use this photo? And so much traffic was, let's say, driven along this picture. So the content, the picture, and the discussion around like, is the consent of the person on the picture necessary for compliant advertising? It was like, there were articles about it in the national or whole country media, and also a short spot on TV. So this is how, I don't know, a small agency in the campaign for a small clinic with a small amount of money hit the national market with, or hit the national market, I would say. And that's probably all for Slovakia. I will just leave the floor for remaining speakers. Thank you for listening. And Anikó, I'm curious about that Cadbury Cream Egg and Hungarian approach.
Thank you so much, Dusan. Thank you. Now I'm the one who continues. So let's talk about Hungary. As you can see, I intend to cover 2 topics, 2 quite recent developments from Hungary. The first one is about the introduction of the so-called anti-LGBTQ+ legislation. The other topic is about the Hungarian Supreme Court annulling the decision of the Hungarian Competition Authority, in which the authority established that Facebook's claim it's free and always will be is misleading to consumers, and imposed a fine of approximately 3.3 million euros on Facebook. So let's start. The law, this anti-LGBTQ+ legislation, which is officially called the Children Protection Act, was adopted by the Hungarian government on the 15th of June, and this is in force as of the 8th of July. The Children Protection Act has the stated purpose of safeguarding children's well-being and fighting pedophilia. Therefore, it introduced new measures to the Hungarian criminal code, and such as registration of offenders and similar measures. However, MPs from the government party have proposed further provisions to the law which are dealing with sexuality and more specifically LGBTQ+ sexual orientations. And you have to know that the legislation has sparked criticism for being discriminatory against members of the LGBTQ+ community and for limiting sex education in schools. The reasoning of the Act sets forth actually that the provisions added will help protecting the healthy development of children by shielding them from content that could have adverse effects on them. As you can see on the slide, as a result of the new law, now it is not only prohibited to make available to children pornographic content and content which depicts sexuality for its own purpose, but it is also prohibited to show or to promote for persons under 18 years old any content regarding the deviation from the sex at birth, gender transitioning, or homosexuality. As a result, the categorization of programs under the Media Act has also changed, and this also includes the classification of ads. Because this is a novelty that from this point on, not only programs, but also ads must be classified TV. So the original system of classification remained the same. The new act brought about changes in connection with programs classified under category 5, which category shall include programs which might impair the physical, mental, or moral development of minors, in particular those that are dominated by violence, deviation from self-identity according to sex at birth, gender transitioning, depiction of or promotion of homosexuality, or direct, natural, or self-serving depiction of sexuality. These programs shall be classified as not recommended for viewing for audiences under the age of 18. And these programs may only be broadcasted between 10 p.m. and 5 a.m. in the morning. In addition to this, a new government decree was introduced, which is in force as of the 5th of September. And the decree basically contains three major restrictions. It prohibits the placement to shop windows and public displays of children's products that depict or promote homosexuality or transgenderism. Furthermore, such products may only be distributed in closed packaging, separately from other products, and such prohibition is applicable only to products that are for children. However, in addition, the decree also prohibits the sale of any products depicting homosexuality or transgenderism within 200 meters of schools and church. Here, the decree does not distinguish between children's products and other products, so it is applicable to all kinds of products. When the new act was introduced in the official gazette, it was very clear that market players do not know how to apply and how to interpret the new provisions. What does depicting or even promoting homosexuality mean? So first, the Self-Regulatory Advertising Board issued a recommendation on how to apply and how to interpret the new provisions. And later, quite recently, on the 15th of September, the National Media and Info Communications Authority, the abbreviation of this authority in Hungarian is NMHH, issued their guidelines on the classification, so age rating of programs, which already included the age rating of commercial advertisements and on-screen pictograms. Since NMHJ is the authority enforcing these rules, we will discuss their guidelines in more details now. So the NMHJ guidelines cover all categories of programs, but now I will highlight the points of the guidelines which are related to the new anti-LGBTQ plus legislation, so the category 5 programs, including ads below. So according to the guidelines, the depiction of gender non-conformity, gender transitioning, and homosexuality is not prohibited in general, which is good news. What requires consideration for classification is whether in a given program, the depiction or representation of the direct contact or relationship between homosexual persons in view of their sexual orientation, or of the gender nonconformity, or of the gender transitioning, is the dominant essential element of the program, whether it is the subject of the program, or if the program depicts or promotes these elements or homosexuality as a behavior to be followed. Then the guidelines clarify what is the meaning of the notions dominant element and promotion. It actually says, it specifies that a program presents issues related to gender transitioning and homosexuality in a dominant way if the content presented focuses on the values and benefits, uniqueness of homosexuality or gender transitioning. So these issues are a central, essential, and indispensable part of the content. I would like to mention here that a summer episode of a Hungarian soap opera that has been running for decades in Hungary included a scene with a lesbian kiss, and the TV channel did not categorize the episode as a Category 5 program. EMEA did not initiate proceedings against the media service provider. It found that the scene with the lesbian kiss did not form a dominant element of the program. Furthermore, the guidelines also explain what constitutes promotion. The presentation of homosexuality and gender transitioning as a social norm, as a more attractive and desirable way of life than the traditional heterosexual lifestyle, and propaganda activities on these topics in the media content aimed at disseminating these ideologies and views, at influencing minors emotionally, and at persuading them by means of communication. And then, the guidelines provide some help in connection with what is not depiction or promotion. It says that general gestures expressing tenderness, such as kissing, hugging, walking, holding hands, should not be considered problematic, provided that they are not depicted, presented for their own sake. They are not the central element of the content, not the main theme of the program, not emphasized, but are clearly intended to demonstrate tenderness, love, togetherness, or where appropriate, compassion. The NMHH brings a few examples for Category 5 works with the above LGBTQ topics. Call Me By Your Name, The L Word, Shameless, Skin I Live In, Generation, Queer as Folk, Lip Service, so all these. And then when categorizing advertisement, it mentions that the number, length, quality, wording, imagery, music, content, comprehension, with or without explanation. So the overall impact on minors of the scenes that are problematic for minors should be taken into account. So basically answering your question or issue raised by Brinsley, I would say that Cadbury's ad would be most likely highly problematic here in Hungary. So I'm pretty sure that it would be a restricted content. Let's move to our other topic, Facebook. Facebook has been a popular target of regulators and authorities for some years now. Indeed, the Hungarian Competition Authority is one of the authorities which have launched proceedings against the social media giant. Here in Hungary, the reason for this were alleged unfair commercial practices carried out by the company. One would think that the expression free and always will be is quite clear. It means that no payment obligation arises when someone uses Facebook services. However, as we look at the definitions listed on this slide, we may indeed ask ourselves whether a service which is available without any monetary consideration, but which requires the provision of personal data, which, as we all know, is of high value and which is then extensively used by the service provider to generate income, is still to be regarded as a service for free. So this was the question investigated by the Hungarian Competition Authority. Although the procedure started several years ago due to several reasons, in October 2016, the claim it's free and always will be was not one of them. The authority started to investigate various practices of Facebook, and finally the investigation was terminated in these respects. However, the investigation was expanded on the for free claim in 2017 based on the blacklist and another provision of the Unfair Commercial Practices Act, the so-called UCP Act. So these provisions were, one provision is from the backlist of the UCP Act, which prohibits describing a product as gratis, free, without charge or similar if the consumer has to pay anything other than the unavoidable cost of responding to the commercial practice or collecting or paying for delivery of the item. And on the other hand, the UCP Act considers a statement misleading if it contains false information or is therefore untruthful or in any way deceives or is likely to deceive any consumer in relation to the price or the manner in which the price is calculated. But you have to know that the UCP Act is the implementation of the European Union's UCP directive, which regulates the B2C unfair commercial practices all over the European Union since 2008. So the provisions based on which the HCA decided to investigate the claim for free is the same all over the European Union. Now, of course, the question is whether the interpretation of this provision is the same too. In its final decision, as I said, the HCA found that the claim is free and always will be misled consumers and imposed a fine of approximately 3.3 million euros on Facebook, which was the largest ever issued fine in Hungary in a matter of consumer protection at that time. The duration of the infringement was quite long, almost 10 years. So let's speak quickly the reasons for the HCA decision. The decision established that for free means for consumers that they are not expected to give anything in return for the service. So there are virtually no material or any other risk of use. Also, since for free is very alluring for consumers, this claim significantly increases interest in a service and it distracts consumers from the nature of the service and thus from making an informed decision. Although consideration is typically the payment of some direct or indirect price or fee, any other commitment or risk is also a form of compensation. And according to the authority, it was misleading that Facebook distorted the picture created for the consumer of price of the service, which is complex and is linked with the data management of Facebook. So the authority stated that when using Facebook, consumers actually pay with their consumer activity data and other information, even from their friends. In other words, while it is true that users do not pay a fee for the service, they pay for their use of Facebook by driving profits to the company through its collection and use of their detailed data, such as consumer preferences, interests, and habits. So for consumers, for free means the complete lack of any type of consideration. Free Facebook registration and use is actually a complex asset with significant market value, which takes place primarily by sharing own and friends' personal data. The fine imposed was also pretty high, at least in Hungarian comparison. The authority calculated the fine imposed on Facebook based on turnover generated by advertising, as according to the authority, it reflects the magnitude of consideration paid by consumers. The starting amount of the fine was 10% of the turnover for 2018 in Hungary, while the general rule is 10% of turnover reached during the entire infringement period. However, the HCA considered this would have been excessive. The HCA took into account two mitigating circumstances, namely that Facebook withdrew free statement in August 2019 and also amended the contents of its help center as of October 2019 globally. As we know, since then also other authorities in the European Union had issues with these types of statements of Facebook. So this might have been also a reason for amending their policies on a global scale. However, Facebook turned to court and yes, they won both at first and second instance. And the final and binding judgment of the Supreme Court of Hungary was passed just this October. And as a result, the HCA decision was annulled. In short, both courts are confirmed that the UCPF cannot be interpreted to the effect that consumers pay consideration to Facebook by providing their personal data. So the court defined the legal issue whether the use of personal data to place targeted advertisements qualify as a price under the UCP Act, or can Facebook be considered free of consumers receive targeted advertisements rather than simple ones using their personal data? And the answer was no. It depends mainly on the context. In general, not just monetary, but different types of disadvantage influencing consumers' decisions can be interpreted as a price of the service when deciding whether something is free or not. However, this disadvantage cannot be an obvious result of the nature of the service in question. So a disadvantage can be regarded as consideration only if it does not follow directly and obviously from the nature of the service, has a direct effect, and is significant, and therefore it is able to influence the transactional decisions of consumers. On this slide, I cited a paragraph from the judgment of the Hungarian Supreme Court, which basically repeats what I just said about the main principles, how to decide if something is free or not. In order to save time, I'm going now further because there is an issue that the Supreme Court left open. Basically, the court said that this was a consumer protection case and not a data protection case, and therefore, of course, Facebook's actions were not assessed from the point of view of data protection, and this was not something which the HCA referred to either. So it's an interesting issue whether Facebook's operation would be okay under data protection laws. It seems that they are okay under consumer protection law. It would be interesting to see what would have been the outcome in other jurisdictions, especially in the European Union or the United Kingdom, and what should be the standard for interpretation. So actually, this is in a nutshell for Hungary. Thank you. And now I'm turning it over to Mariam from the United Arab Emirates to listen to her thoughts.
Thank you, Anikó. Hi, everyone. Just going to get control of the slides and come in. Hi, everyone. My name is Mariam Sabet from Tamimi, based in Dubai. I just wanted to give a brief overview on 2021, what happened in the UAE, what are the new laws that came out. I'll try to be brief and concise. So basically, some regulatory changes happened in 2021. We've had new regulatory body, just basically a restructuring of the current media regulatory body. We'll cover that briefly. We'll cover briefly the new consumer protection law, and especially there's a new misleading, new rumors and electronic crimes law that was issued a couple of days ago, along with the UAE personal data protection law. Actually, the UAE has issued last week a record-breaking 40 new laws, literally last week. So we're still in the situation room, just trying to look at all the different laws and what they're covering, but it's literally 40 new laws. So just taking you next. The new media regulatory body, basically, as I mentioned, historically, it's always been the National Media Council. that issued all the media laws and regulations. There has not been any new laws and regulations since 2018 with respect to media, but they did have a new regulatory body replacing the National Media Council, which is now currently the Ministry of Culture and Youth. So far, they are still working on the current national media laws and regulations, which has the traditional what are the advertising do's and don'ts and the content, but these are not new for 2021. So far, we're expecting with the new MRO, which is the Media Regulation Office, we're expecting possibly around 2022 that new laws for media would be issued, since we've already had 40 new laws in every other aspect. Basically, for the role in the MRO, they have two departments, which is the Media Regulation Department and a Department of Media Licenses, which you need to get new licenses for content. Basically, if we go and move into the advertising restrictions, so as I mentioned before, the NMC, formerly the National Media Council, this is currently the legislative landscape and regulatory landscape for media in the UAE. No changes currently in the advertising content 2017 or the advertising standards or the guidelines or even the e-media law. But when we go further a little bit and talk about the new electronic crime law and the rumors law, there's going to be a little bit of impact on that. But currently now, all we can see is that there's been a huge increase in focusing on digital content, obviously, and basically these laws are applied both offline and online. And the good thing is that they also apply to free zones, because historically we've had issues in enforcement in free zone areas, and most of the companies are regulated in free zones. So the laws specifically cover free zones to make sure that it's not only for onshore companies. With regards to influencers and e-commerce providers, basically it's, again, no new changes have occurred so far. All advertising materials, you need to have disclosures and hashtag ad or paid ad. So far, again, back again to the same content that we had in 2017 and 2018 for advertisements. There are special rules for energy drinks, medicine, and basically promotional campaigns, especially those related to the Hajj and Umrah campaigns in Saudi Arabia. Now, I was mentioning the new consumer protection law. The new consumer protection law is very interesting. It was issued in 2020. We were expecting to have by now the executive regulations. It's yet to be issued. But what's interesting is that it specifically applies now to e-commerce providers. Before, there wasn't any regulation about who can have a website or social media account. With the e-commerce law, it specifically requires all those that have social media accounts and businesses online to obtain a certain license. But basically what's really interesting is that the new consumer protection law covers now misleading advertisement. Now we're all eagerly awaiting basically to see the executive regulation and to see what exactly it will cover. But one of the important things about the e-commerce, the new consumer protection law, is a specific section with regards to data privacy. And the way the article is formulated, that it appears to impose a ban on the use of consumer personal data for promotion and marketing purposes. I don't think, and we don't think, that this really means that the law meant to ban, to prohibit completely the banning of consumer personal data for marketing purposes. But again, it's there, it's still an article in the law, so far it looks like it's banned, but I think we're waiting for the executive regulations to just explain and clarify what did they mean exactly about the banning of using personal data for marketing. So far, we've all still receiving in the UAE all kind of, promotions and all kind of advertisements. So I'm sure people are still doing it as we speak. So again, we are still waiting for the consumer protection law to cover that. The new consumer protection law as well, the executive regulations, is yet to comment on other aspects. But again, it's mentioned that you need to have a license for promotion. And you need to have a specific license from the competent authority if you are going to have any discounts or advertise any other types of promotions. So this is for the new consumer protection law, and I am conscious of the time here. So I'm just going to try to go a little bit more faster, if that's okay. With regards to the rise of sweepstakes and contests, nothing new from our side so far. Still, it is tricky to have, games of chance are not allowed because it can be conceived as gambling. But we've seen an increase of skill-based games, which is actually even including in the commercial transactions law in the UAE, but so far it's generally still prohibited with regards to gambling, and lotteries as well. But we'd expect certain changes to happen in the future, or companies to be a bit more smart and try to gear their activities into more of a skill-based games. Okay, this was issued last week, which is basically the new rumors and electronic crimes law. This law replaces the old cybercrimes law, which was very focused on traditional cybercrime matters. It did not include at the time any advertising at all, only sharing and transferring of video that has illegal materials. And of course, the old law had prohibited content for pornography and gambling, but the new law basically criminalizes actually misleading advertising. This is actually a very big development. Obviously, we're still waiting for the executive regulations, but for now, basically they criminalizing misleading advertising. They criminalize publishing and sharing fake news and rumors. Actually, not only that, if you circulate, reshare an item that is considered to be fake news or offensive, you are also part of that provision that penalizes you. So these are huge reforms that happened, and everyone is still looking at it, interpreting it in our way. So I'm expecting 2022 to be a very busy year in terms of the repercussions and impact of this new law. But specifically with respect to advertising, it's interesting that it specifically covers misleading advertising, and it's now a criminal offense. Another point as well with regards to content, there's a specific clause that covers content and any content that is prohibited by any law. So we have a bunch of media laws that tells you what kind of content is prohibited. For any party, even the person that is hosting the website or the platform would be also penalized for having prohibited content. And interesting enough, this particular clause has been considered as an offense against national security, because if the content that are being the content that is out there, if it's concerning prohibited content, that will be considered a national security offense, and it's very serious offense. Obviously, again, waiting for the executive regulations to see how this will all pan out. So 2022 will be a busy year. Finally, next I move on quickly to the new data protection law that has as well been issued last week. Basically, it just formulates the creation of a UAE data office. There is a new regulatory authority now to implement the national data protection law. Basically, the law, again, it's in line with the best practice and principles, and they have regulations for how you file complaints before the UAE data office. Without an executive regulations, there are still lots of questions of how it will be implemented. But so far, the law is out there, and it's still being processed, but nothing controversial in that it's compliance with the most global practices out there. Okay, and finally, so far, I mean, what we expect in 2022, well, first of all, we expect the executive regulations on all the 40 laws to be issued. Hopefully, we'll find out more of what will happen for the executive regulations for the rumors and cybercrime laws. And in terms of specific focus on advertisement, we're expecting guidelines on influencer marketing, NFTs, more on films in the UAE, and possibly, hopefully, the music industry, because currently we do not have a collective society, so this causes issues as well. Sorry, I ran a little bit quick because we were out of time, but that was just a brief, concise run through about UAE. Thank you.
Thank you very much. Esohe, please, the floor is yours.
Thank you, Anikó. Good afternoon, everyone. So my name is Esohe Olajide. I'm a senior legal consultant at Integrated Legal Consultants, Ghana. For Ghana, for the year in review, I would just do a brief introduction or overview of how advertising is regulated in Ghana. Because we do not have a principal legislation, as the advertising bill has been pending before Parliament for quite a while, what currently obtains is we have sector-specific regulation of advertising. So some of the key regulators of advertising in Ghana include the Food and Drugs Authority, which is the FDA, which gets its power from the Public Health Act 2012, the National Communications Authority, the NCA, the Gaming Commission, which regulates things like games, contests, bets, and all of that. And the FDA and the NCA and the Gaming Commission usually also have authority to come up with guidelines or instruments that help players to understand what kind of limitations or how they want advertisements to be put out in relation to the relevant sectors. The Food and Drugs Authority also is very particular about what kind of advertising is done in relation to foods and drugs, medicines, and household chemicals. It even sets out guidelines with respect to packaging, labeling, content, and it also specifically requires pre-approval. So any kind of advertisement that is going to be put out with respect to foods, drugs, or any of the products that the FDA regulates, the scripts, everything have to be approved. And then all of those advertisements, whether they're on TV, radio jingles, and billboards, outdoor, everything has to have a line or a clause that says this advertisement is approved by the FDA. If you don't get the approval, and then your advertisement can be taken down or you can be sanctioned. We also have an industry self-regulator, which is the Advertising Association of Ghana. So this is just a body of private practitioners and advertising agencies in Ghana who have come together to form this association. And the association has its standards and which is contained in its code of conduct and ethics, and it spells out what kind of things members are supposed to do, what they're supposed to adhere to with respect to advertising. And these standards are binding only on members of the association, but the code also provides sanctions and fines for members who breach them. So for this year, I'll be looking at regulation of advertisement of food and drugs in relation to treatment of certain ailments, including COVID-19, ban on influencers and celebrities from endorsing alcoholic beverages by the FDA, ban on the use of celebrities in advertisements in relation to gambling, and the proposed LGBTQA+ legislation in Ghana. The Public Health Act, which is what empowers the FDA, prohibits advertisement of products that are regulated by the FDA without prior approval, as I've said. And then it has all these guidelines where you have to seek approval for any kind of advertisement. It covers all. I mean, even though the guidelines of the FDA with respect to advertisement don't specifically provide for online marketing, but any kind of marketing, even online marketing, seems to be regulated by the FDA, and all of those adverts must be pre-approved. By Section 114 of Act 851, the FDA specifically prescribes guidelines for advertisement with respect to drugs, household, chemicals, and cosmetics. And these guidelines prohibit advertisements for prevention, treatment, and cure of certain diseases, which include STDs, forms of genitourinary diseases, acquired immune deficiency syndromes, AIDS, or diseases that are connected with human reproductive functions. And of course, with the advent of COVID-19 and all the uncertainty that brought, the advertisement of medicines or products or items that had to do with the treatment of COVID-19, including vaccines, was also prohibited. As we've observed around the globe, particularly when the world is still trying to find vaccines or any kind of treatment for COVID-19, when anyone made any allusion to a particular drug or product that could be used as treatment or was being used to treat patients in the early days, and there would be a sudden rush to go and purchase that product, and there'll be a lot of posts or claims, some even trying to advertise with respect to that. And so the FDA has had to release disclaimers by way of press releases to say, you know, you can't advertise any of these things online. You can't advertise treatment for COVID-19 and even COVID-19 vaccines online. These are prohibited. We had an instance of a food supplement in Ghana, COA-FS, which was allegedly being used with the treatment of patients by a specific facility that was designated for caring for persons who were infected with COVID-19, and thus this led to a sudden rise in the demand and purchase of that particular supplement by the public, and they had to issue a press release to that effect. Section 129 of Act 851, which is the Public Health Act, stipulates penalties which ranges between 7,500 penalty units and not more than 15,000 penalty units, or a term of imprisonment of not less than 15 years and not more than 25 years, or both. So you could have a fine, you could have imprisonment, you could have both as punishment for anyone who is convicted of contravening sections 118 to 124 of the Act. So this is just an example of the press releases that the FDA had to issue. Then we'll also be looking at the ban on influencer marketing. Well, the FDA, as a major regulator in respect of advertising, usually there's advertisement of tobacco products that ordinarily is allowed, but they introduced a ban with respect to advertisement of alcoholic beverages, where they sought to prevent celebrities, online personalities, movie stars, and generally just influencers from endorsing or being used to advertise alcoholic beverages. In Ghana, the alcoholic beverage market is quite big, and so quite a lot of celebrities and influencers actually generate their income, a large portion of their income yearly from these kind of endorsements. But the FDA introduced this ban as a way of protecting children who they believe are largely followers of children and young people who, and children, according to the FDA or most of our statutes, are persons below the age of 18, and they believe that allowing influencers to advertise or endorse alcoholic beverages would lure them into alcoholism, and they introduced this in line with the World Health Organization's policy at the time. Of course, there have been a lot of objections and kickbacks and reaction to this ban by celebrities because it has affected their revenue, especially with the advent of COVID, where they couldn't even have any events or shows where they would have generated income. And there's been constant request or call for the FDA to revisit this ban by artists and celebrities. However, the FDA has maintained the ban and has advised celebrities and influencers who have any issues or believe that their rights are being infringed to go to court. We have, however, not recorded any cases in this regard. So we've had some key celebrities who repeatedly post stuff or articles or comments with respect to this ban. We've had Wendy Shea, we have Shetawale, Fehr, and all of them keep decrying the ban and how it affects their income. With respect to influencer ban as well, we also have the Gaming Commission, which usually regulates operators of games of chance, sweepstakes, contests, gambling, and all of that. And it usually has guidelines and advertisements. It requires advertisements with respect to gambling to have basic warnings to protect the public. Things like gambling is addictive, gamble responsibly, not for people less than 18, are basic requirements that advertisers must comply with. In October 2020, the Gaming Commission also introduced its ban on the use of celebrities in advertisement by promoters of activities in relation to gambling in order not to entice people to bet. The reason behind this was to try to discourage the use of celebrities to make gambling look attractive or to portray the celebrities as being better people or being more comfortable people because they gamble. So the guidelines specifically said that operators shall not use celebrities in the advertisement and entice the general public. And we've also had celebrities speaking up against this ban and further decrying it, along with the ban currently being imposed by the FDA because it affects their source of income and they feel it's not being fair to them. And some have complained that it is allowing foreigners to take their business away from them. And another interesting thing that has happened this year is the proposed LGBTQA+ bill. So earlier this year, a bill was proposed or presented by some parliamentarians titled Promotion of Proper Human Sexual Rights and Ghanaian Family Values Bill 2021, quite a handful, I must say. The aim of the bill was to regulate the activities of LGBTQA persons in Ghana and to regulate the promotion of such activities. It's quite an extensive bill. It tried to define various words used in the bill because the bill is meant to cover activities of all kinds of people. So asexual, bisexual, gays, lesbians, queers, LGBTQA, LGBTQIAPP+. It's defined, it even goes to define Ghanaian family values to include respect for sanctity of marriage as a lifelong relationship between man and woman, especially of whose gender is assigned by birth. So basically the bill proposes to outlaw a lot of activities by persons with respect to gender, as long as it is not gender assigned to those individuals by birth. It prohibits or proposes to prohibit the grant of an order of adoption of a child to persons who are defined to include gays, lesbians, queers, LGBTQ, and all of that. And anyone who is a male or female whose gender is not assigned by birth. It tries to prohibit marriage between any persons who are not male and female gender assigned by birth. It proposes to prohibit a grant of an application for fosterage when the applicant is gay, lesbian, queer, etc. And anyone, male or female, whose gender is not assigned by birth is definitely affected or will be affected by this proposed bill. And the unique thing about this is that the bill proposes to criminalize some activities or many activities actually with respect to the persons who have been defined. It proposes to criminalize LGBTQA plus advocacy, which is what is relevant to us as advertising law experts. And it also provides for prison terms for offenders. So the bill proposes a fine of between 1,000 to 2,000 penalty units, and a penalty unit is about $2. It also proposes to prohibit promotion of LGBTQA activities by media. So if you are a media outfit and you promote LGBTQ activities, you would be in breach of this proposed bill, and it could attract a prison term of between 6 to 10 years. Also, the proposed bill proposes a prison term of between 5 to 10 years for persons who sponsor LGBTQA plus activities. There are quite a whole lot of prohibitions, fines, and prison terms. It even regulates the kind of medical treatment that can be given, and it also regulates how the other people relate to them. So if you attack or shame an LGBTQA person, you also would be an offender under this act, and it also prescribes its own sanctions. The bill attracted quite a lot of debate, still ongoing. We await the outcome of the debate. We do not know if this particular bill will make its way through all the stages of passing legislation at Parliament, but it's quite an interesting bill, and I would say that it probably would have been nice if the promoters of this bill had tried to look or borrow a bit from the angle that Hungary has used in trying to propose legislation or prohibitions that would limit exposure of young persons, or trying to promote LGBTQ activities to young people, or getting them to be concerned in transforming their gender, rather than just criminalizing a whole lot of things. So we'll wait to see how that turns out. Finally, I had mentioned that there was the industry self-regulator, the AAG. Well, they, over the course of the year, have consistently put out articles and publications pushing for the pending advertising bill to be passed into law, because they're of the opinion that this would lead to a properly regulated industry. It would protect consumers and local investors in the sector. They have also expressed their worries and delays in passing the bill, and they believe that this is allowing big foreign advertising agencies to take over the advertising market in Ghana. And for me, that is the end of my year review for Ghana. Thank you.
Thank you very much, Esohe. This was really, really very interesting. And thank you to all our panelists today. Thank you very much for the attendees for signing up for this webinar. We really enjoyed it very much, and we hope that you did enjoy it too. Please feel free to email us if you have any questions. And also check out our future events at our website www.galalaw.com and join us for our future events. And finally, on behalf of the entire Gala team, we would like to wish you a pleasant and peaceful holiday season, and all the best for the new year. So see you soon. Bye-bye.
Bye.